morning. Good morning. I'd like to call the special Planning Commission meeting for April 23rd, 2018 to order. If you would, all rise for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good morning. All right.
Good morning.
We have a substitute county attorney and a substitute staff member on the
Substitute, huh?
Yes, sir. For the record, I'm Assistant County Attorney Bill Clegg, and
I'm Rob Brown, Parks and Natural Resources Division Manager.
Have there been any changes to the agenda, Mr. Brown?
No, sir.
Thank you.
Mr. Chair,
Clegg.
these four items are interrelated, so under the applicable case law, you do have the discretion to handle all of them in a single public hearing. It is your decision. I think that would be the applicant's preference, and if I'm not mistaken, that's also staff's preference, only because the discussion of each basically would be redundant if otherwise. So, but it is your choice to open them or in separate hearings or in a single hearing.
Thank you. And for the applicant, is that the preference? Can we get an acknowledgement? Okay, the applicant's knowledge in the affirmative that would be their preference.
Well, then, if that's your decision, I would ask you to ask Mr. Brown to read each item into the record to open the hearing.
Okay. This is a special planning commission. Do we still need to have citizen comments? Do we not?
I don't know. Is it on the agenda? Is it listed on the agenda? Because if it's not, then I think you should.
Okay. All right. So the next item on the agenda is citizen comments. This is an opportunity for anybody to come forward and speak on something that is not on today's agenda. So if you have something that's not on today's agenda, please come forward. If you wish to speak on the items that are on the agenda, you'll have an opportunity a little bit later on. So, okay, seeing nobody come forward for citizen comment, we're going to close that portion of the hearing. And we're going to move on to the advertised public hearing items. Mr. Brown, could you read item number 1 into the record, please?
Yes, sir. Item number 1, Resolution R18012, Master Mining Plan, Wingate Creek Mine. A resolution of the Board of County Commissioners of Manatee County, Florida, amending the Master Mining Plan for the Wingate Creek Mine to authorize the following: approving to beneficiate, process Wingate East Mine phosphate ore at the Wingate plant, amending the trucking schedule, mine plan schedule, and reclamation schedule to accommodate the processing of ore, allowing the exchange of Wingate East Mine sand tailings and overburden with the Wingate Creek Mine, updating the water disposal plan according to the amendments above, allowing the continued use of the approved Wingate corridor, incorporating amended and restated conditions from the Development of Regional Impact, Development Order 13-01, providing for enforcement and severability, providing for the effective date, extending a build-out date for mining until July 31st, 2037, trucking until July 31st, 2037, and reclamation until December 31st, 2042.
Thank you. Can you read item number 2 into the record?
Item number 2 is Resolution R18013, Master Mining Plan Southeast Tract Mine, a resolution of the Board of County Commissioners, Manatee County, Florida, amending the existing Master Mining Plan for the Southeast Tract Mine to authorize the following: establishing new or modified conditions of approval for mining activities within the Southeast Tract, removing 103 acres of land in Section 22, 23, 24, 26, and 27, or parts thereof, in Township 34 South, Range 22 East. Revising the waste disposal plan to include waste clays from the Wingate East mine, updating the mine and reclamation schedules to take into account the above changes, incorporating amended and restated conditions from the Development of Regional Impact Development Order 08-020, providing for severability, providing for an effective date, providing for an expiration date, approving a build-out date for mining activities until September 30th, 2037, and reclamation until September 30th, 2042.
Thank you. Could you please read item number 3 into the record?
Item number 3 is a local development agreement, LDA 17-04 Wingate Creek Mine. And this is a request for approval of a land development agreement for Wingate Creek Mine. The local development agreement retains vested rights and to eliminate any inconsistencies between DRI development order and the pending master mining plan amendment. The DRI-DO ordinance 13-01 is to be rescinded in conjunction with the approval of the LDA 1704.
Thank you, sir. And then finally, could you please read item number 4 into the record?
Item number 4 is local development agreement LDA-17-03 Southeast Track Mine. This request is for the approval of the local development agreement for the Southeast Track Mine. The local development agreement retains vested rights and to eliminate any inconsistencies between the DRI development order and the pending master mining plan amendment. The DRI-DO ordinance 02-20 is to be rescinded in conjunction with the approval of LDA 17-03.
Thank you. Thank you. Mr. Clegg, it's my understanding that all 4 of these items are quasi-judicial. Is that correct?
That is correct, so I would ask the clerk to conduct the swearing in.
Thank you. So if you have a idea that you may speak today, please rise to be sworn in. If you don't do it now, you'll do it during the meeting. So.
Do you swear or affirm that the factual statements and factual representations which you are about to present to the Planning Commission will be truthful and accurate?
I do.
Thank you.
Thank you. All right. For the commission, have there been any ex parte communications on this matter?
No, sir.
Okay. All have acknowledged negative. So, okay.
Mr. Chairman, just a question.
Yes.
I know we're going to have a presentation collectively, but how are we going to vote on these? Individually?
We will vote on them individually.
Okay, thank you.
Correct, they have to be handled through individual motions.
And I've also had a discussion with the county attorney's office, and to protect the procedural integrity of the meeting, that when it comes time for public comment, they'll have time to speak on each item. So it'll be Mr. Clegg.
Yeah, the point is that the applicant is asking for their time for each item. They're not sure they're going to use all of it, but because they want the full amount of time for each item, we have to grant those same rights to individuals who want to address the Planning Commission in order to maintain procedural due process.
Thank you. For the applicant, what is the typical?
It's 15 minutes for a presentation.
I would say 4 times the typical for each one. I don't expect we're going to have a presentation that lasts that long, but if it does, we'll know. All right. So we've had an introduction of the items by staff. So if the applicant could come forward, please, and do your presentation with regard to the applications, please.
Good morning, Commissioners. My name is Hugh McGuire, and I'm here of the firm of McGuire and McGuire, and I'm representing Mosaic
And you have been
Advisor
sworn.
LLC, and I have been sworn.
Thank you, sir.
With me are John Folletto, a senior corporate counsel from Mosaic Company, my partner Carol Massell McGuire, and Vanette Gedalia from the firm of Hopping, Greens, and Sams in Tallahassee. We have others, and let me put your mind at rest. We don't anticipate taking 80 minutes, okay? I think that we have, if I'm not mistaken, 15 for presentation and 5 for rebuttal for each one. I don't anticipate anywhere close to that. But we do have our consultants and staff and Mosaic folks that are here to answer your questions if you have any. We're here really on 4 items and for your consideration and approval, and I'll explain each one and their effect on our request, and you'll hear more of the presentation as we go through it. But first, I'd like to give you a little bit of a background, and you can see on this exhibit, there are really three different mines that are affected here. Back in February of 17, we received approval from the Manatee County Board of Commissioners for the rezoning of 4,341 acres of land adjacent to the southeast tract and the Wingate Creek Mine to a zoning classification of extraction. This tract is called Wingate East. You can see that in the green. At that time, we also received approval of a master mining plan, which governs the process of mining and reclaiming that property. Material mined at Wingate East will be processed through the plant located on the original Wingate Creek Mine, and you can see that in the blue, and you see the little star, which is the location of the plant. And then the clays will be stored over on the southeast tract, which is the pink area, and those are the two clay settling areas. In order to process the materials from Wingate East through Wingate and then up to southeast, we need to amend the existing master mining plan on both of these tracts. Resolution R-17-017, which established the approval for Wingate East that I was referring to earlier, stated, and if I could read, prior to and coincident with an application for an operating permit for the Wingate East mine, the developer shall submit applications for amendments to the Wingate Creek Mine and the Southeast Tract master mining plans and operating permits. That's why we are here today. That was all envisioned in the passage of the February 17 hearing. Let me say that we're not asking for any additional land to be rezoned. We're not asking for any increase in permitted water withdrawals. We're not asking for any new clay settling areas, and we're not asking for any additional trucking routes. Our requests today are basically twofold: to modify the two existing master mine plans to allow this process that I just explained, and then for those and the use of those facilities, and then to be able to continue our mining. For decades, Manatee County has required approval of a master mining plan and an operating permit in order to mine phosphate. In addition, we were required to go through a development of regional impact. In 2011, the legislature removed that requirement for mining operations, and the review process was handed back to the counties. As a result, we're now asking to move those DRI development order provisions over to the master mining plans. In addition, we're entitled to certain rights that we call vested rights, which are county regulations in force at the time certain operations were permitted many years ago. These rights are set forth in the local development agreements that are before you. The removal of mining from the DRI process is found in Florida Statutes, Chapter 380, and the local development agreement authorization is found in Florida Statute 163. Finally, it's our position that our applications, submittals, staff recommendation for approval, and the applicant's testimony that you will hear in these hearings comply with the provisions of Florida Statute 163, Florida Statutes Chapter 380, the Manatee County Comprehensive Plan, the Manatee County Land Development Code, and the Phosphate Mining Code of Manatee County. I want to now introduce Michelle Tickles, Wingate East Project Manager for Mosaic Fertilizer, LLC. And after she speaks, Darren Stowe, AICP, who is an urban and regional planner with environmental consulting and technology, will speak. Thank you.
Thank you. Good morning.
Good morning, Commissioners. My name is Michelle Tickles, and I'm a senior permitting specialist with Mosaic. I have over 15 years of experience in the reclamation and permitting components in the phosphate mining industry, and I've been sworn. Today I'm going to talk to you a little more at length about the Wingate East Master Mine Plan approval and the follow-up items that we're here requesting today. So just to orient you within the county, I know Hugh also showed a slide, but to zoom out a little bit, we're in the easternmost portion of Manatee County here. So again, in pink, we kept the color coding the same throughout. So we have Southeast Tract in the pink, Wingate East in the green outline, and Wingate Creek in the blue. For all three of these sites, we have our state and federal approvals obtained, most recently for Wingate East in February of this year, or January of this year. And this is again, the follow-up requests we're making as a result of the Wingate East Mastermind Plan approval. So just to go over shortly, I believe you'll hear more about this later. Wingate East, as Hugh mentioned, was approved back in February of last year, and we're requesting no changes to that existing BOCC approval. All those existing components remain the same, and Wingate Creek and Southeast Tract amendments that we're requesting here are all in order to meet those approvals from last year. For the Wingate Complex, the amendments and approval are being asked to align what we have going in existing operation. So for Southeast Tract, we're looking to accept Wingate East clays to the existing built clay settling areas that have existing clay capacity. And again, that's a benefit in order to minimize any future clay settling area construction. And we're also wanting to accept Wingate East ore to be processed officially over at the Wingate Creek existing beneficiation plant. The operations are already directly connected through a corridor that was mentioned, that was carved out from the Southeast Tract to be officially part of the Wingate East Tract. So there's already a logical corridor and existing infrastructure combining the three property sites. Going in a little further to the Wingate Creek existing approvals. So currently it operates under the DRI Development Order and Mastermind Plan approved back in 2013. And again, these current requests would align those approvals up to the 2017 Wingate East approvals, and the remaining applicable provisions of the DRI were assessed and pulled from the DRI and added to the Wingate Creek Mastermind Amendment now. So these are just the high points of the amendment. Outside of the components that we added from the DRI, the amendment would update the 2013 version to allow the plant to officially accept Wingate East ore to be processed, and then also transport the sand and clay associated with that mining activity back to Wingate East or the associated clay settling areas. It would allow us to continue using our approved transportation network for the additional years of mining that Wingate East has now provided. All of the components of our transportation plan remain the same. They were either pulled from the DRI and inserted into the Mastermind Plan, or they continued in existence from the previous Mastermind Plan. We've actually added additional conditions and requirements to the Wingate Creek Mastermind Plan in regards to transportation as well, including additional transportation notification requirements, and then also a partnership condition in regards to the future replacement of the Duet Road Bridge. It changes the timing of when we would complete mining at Wingate Creek, thus changing the timing of when we would reclaim those areas at Wingate Creek. All of this would occur after Wingate East has been completed. And this just goes back to the logical movement of the dredge and how it would be mining its way back to Wingate Creek as it was previously imagined, but obviously Wingate East adds to that timing. And it updates the final reclamation plan requirements to the most recent DEP conceptual reclamation plan requirements, which was approved in 2015. So it aligns with the state and federal approvals and the requirements associated with that. So the most recent updated 62C16 state reclamation standards as well. Moving on to the Southeast Tract, it's operating also under a DRI and Mastermind Plan approved back in 2008. And again, these current requests would update it to align with the 2017 Wingate East Board approval and the remaining provisions of the DRI Development Order. So it updates that 2008 version to align timing with the clay settling areas. And again, these are already constructed clay settling areas that have available storage to receive clays associated with Wingate East mining. And it uses the existing operation and the existing infrastructure, so it minimizes any need to put out redundant infrastructure for Wingate East or to repurpose areas that may have already been reclaimed. We're able to use areas that are currently in operation. The reclamation at the Southeast Tract, it'll continue until it's complete after Wingate East clays are completed for storage. A majority of the Southeast Tract, and I'll mention this in a later slide, has been reclaimed, but for this corridor and the clay settling area footprint. And then Hugh mentioned it removes Wingate Corridor from the southeast tract. On the previous map, if you notice, that corridor actually was at the northernmost boundary of Wingate East, so it was only logical from a geographical standpoint and from an operations standpoint to have that be part of Wingate East rather than southeast tract. So the effect of these amendments, overall, they include timing changes related to reclamation. The related change, they are all directly related to the continued use of the infrastructure, the use of available clay storage, and the changes in the mine plan associated with the addition of Wingate East acreage. Just to give you an idea, though, of reclamation will continue in Wingate Creek. It doesn't halt all reclamation going on in Wingate Creek. There's still areas that aren't associated with the mining change or infrastructure that are available and will become available to be reclaimed, and we'll continue that process. And that's indicated on the timing maps of when reclamation would occur. You'll still see reclamation occurring in the years 2018, 19, 20. All reclamation is not moved to the end of the life of the mine. So for the southeast tract, we've actually reclaimed over 99% of what's available to be reclaimed. And to put that into context, when you were looking at that map, that's basically everything but the clay settling area footprint and the pipeline corridor. For Wingate Creek, we've reclaimed about 83% of what's available, and that's basically due to remining of areas. So obviously, while we're remining them, we're not reclaiming them. So we'll continue again to move forward further on that percentage of Wingate Creek reclamation. And this updated schedule is consistent with all the state permit requirements as well for the rate of reclamation, and we'll continue all of our county and state financial assurance mechanisms for any area that has been disturbed and hasn't met the county's performance standards. There'll be bonds continued and updated annually to cover future construction costs for monitoring, maintenance, construction of any area that's been disturbed and has yet to be reclaimed on an annual basis. And as mentioned before, the local development agreements, we did a full assessment of the DRIs, all their attachments, all their exhibits, and took areas that were solely in the DRIs and pulled them into the master mine plan if they were applicable to our future operations. There's some items that we had completed, and we see them being complete for all of our future operations, so those would have been memorialized in the LDA. For things that we would have to do on an annual basis, we've added those to the master mine plan, into their exhibits, and to the maps. There were certain maps that were only in the DRI that were not in the master mine plan, so the master mine plan received additional maps now as well. And it maintains the vested rights that we had in either the master mine plan or the LDA. It maintains those moving forward. They remain unchanged from those existing approvals. And again, it removed the requirements that were either completed or they were solely related to a DRI process that, as Mr. McGuire mentioned, is no longer in effect. So just in summary, many items remain unchanged as a result of this master mine plan amendment. It's only a combination of several approvals now in one document or memorialized in the LDA. The master mine plan amendments in LDA, they allow the logical use of infrastructure that's already in place, the use of available clay storage in constructed clay settling areas, the continued employment at the operations, and it achieves compliance with the requirements ultimately that the Wingate East Master Mine Plan asked us to do. So I will now hand it over to Darren Stowe to continue talking with you about the LDA and how that requirement is being fulfilled. You're right behind me. Okay, snuck up on me.
Good morning, Commissioners. My name is Darren Stowe. I'm a certified planner with Environmental Consulting and Technology Incorporated. My business address is 1408 Northwest Shore Boulevard in Tampa, Florida, and I have been sworn. I have over 30 years' experience reviewing comprehensive plans and land development codes for compatibility and consistency. And today I'm speaking to you about the proposed continuation of the Wingate Mine and Southeast Tracts through amendments to the master mining plans, to the rescission of the DRI, and the preparation of development agreements. As has been mentioned, but I'm going to say it again, no comprehensive plan amendments or rezonings are required for what's being requested today. The mines already have the required extraction zoning designation. The proposed amendments to the MMPs, the master mining plans, continue the use of the beneficiation plant at Wingate Creek. They continue the method of transportation from the plant, and the continued use of the clay settling areas at the southeast tract. It is important to note that there is no new mining being requested at either location, and there will be no new land use impacts. All activities will occur within the existing footprints. The same activities that were found to be compatible before will remain compatible in the surrounding area. The changes to the MMP will not result in any additional impacts to water use or air emissions or require an increase in the capacity to dispose of industrial and domestic solid and liquid waste. There will be no changes in the demand for public facilities or services, including police, fire, recreation, schools, and the transportation routes will be unchanged. The proposed amendments to the MMP Ps are consistent with the Land Development Code and with Ordinance 0439 where that is applicable. The proposed amendments are consistent with the comprehensive plan. The development agreements are consistent with Chapter 163 Florida statutes because Wingate Creek and the Southeast Track continue to be consistent with the comprehensive plan and the Land Development Code. Finally, the amendments to the MMPs carry forward necessary commitments from the DRI development orders, as you've heard, and are therefore consistent with the requirements of Chapter 380 Florida statutes. And with that, I'll turn it back to Mr. McGuire.
Thank you, Jerry. Commissioners, that concludes our presentation. We would respectfully request the Planning Commission to approve the amended master mining plans for Wingate Creek and Southeast Track, as well as the local development agreements between Manatee County and Mosaic to replace the DRI orders. Mosaic representatives are here and are present to answer any of your questions. Thank you very much.
Thank you, Mr. McGuire. I do have a question. There was a mention of a reclamation bond.
Yes, sir.
Or bonds.
Yes, sir.
Who are the beneficiaries to those bonds?
Michelle, you want to deal with that?
Yeah, we maintain two separate bonds, a general surety bond and a reclamation liability bond, and I believe the county is the beneficiary to both of those. Those are the county-required bonds, and then there's also state-required financial assurance mechanisms for wetland mitigation in which the Department of Environmental Protection would be the beneficiary for that financial mechanism.
Okay.
And those are, again, all updated on an annual basis after agreement with county staff on the numbers of reclamation achievements based year to year.
Okay, thank you. Any additional questions for the applicant?
Do we know the amount of those bonds?
Mr. Roth, if you would, please direct your questions to the applicant.
Do we know the amount of those bonds?
I can go to a quick table, Mr. Commissioner.
At any time soon.
And not to answer your question, but it's my understanding that these bonds are, you said they're replaced?
Yes, sir. Yes, Mr. Chairman. They're updated on an annual basis. So the bonds are broken down for reclamation liability, for example, depending on how many acres have been disturbed but not backfilled. That obviously has a much greater amount for construction costs per acre in order to complete that area back to the performance standards that the county requires in the code, versus an area that has been perhaps revegetated, reclaimed, that is yet to mature to receive release from the performance standards. That would obviously be a maintenance amount per acre. So that per acre component is completely added up, and based on our reclamation advancements year to year is either updated to be increased on an annual basis or decreased. For example, for Southeast Tract, as all we're doing, we're no longer adding disturbed areas, we're reclaiming them back. So that one seems to decrease on an annual basis, whereas Wingate Creek and future Wingate East would increase based on any footprint changes for disturbance.
Question.
Mr. Roth.
Who on staff regularly checks those amounts to see whether...
If I could answer that, Hugh McGuire. Mr. Brown is meticulous on these requirements, on making sure that we stay up to date on all of our bonding requirements, and those are reviewed, seems like very often, but Mr. Brown wanted to speak to that.
Staff looks at those bonds. Actually, those bonds are, they have, a third-party engineer look at those calculations, and then staff looks at those annually, and they're updated, as they said, during the annual reporting period.
Thank you.
Thank you.
Mr. Chair, I'm sorry.
Mr. Clegg.
I do need just to get some clarification from the applicant's counsel. So Hugh, is that the conclusion of your presentation on all the items?
Yes, sir.
And I'm sorry to put you on the spot, but Could you just give them a brief explanation of what the LDAs do and, and why they're being asked to do them, or do you want to take a few minutes to talk about that?
The LDAs, what we're doing, basically, we're moving over the vested right provisions that we have had, because there were certain rights that were, this mine started in, I think, in 1975. And it was, I think in the beginning, there really wasn't a mining ordinance, and then we went to the second stage, and you'll probably hear that in the staff's presentation possibly. But then we went into the passage of 8122, which we were under for years, and there were certain elements of that we have had to adhere to. And then after 8122, 0439 was enacted, and now we have to live with the terms of 0439, except where there were certain rights that we still maintain, and we call those vested rights. And if you need more explanation on those, we can give that to you, but they deal in part with some of the reclamation under the, and 8122 doesn't control all three areas. I mean, it's basically with the Wingate Creek mine. And so we just want to preserve those, and that's what the LDA does. And because, as I said, we don't deal with the DRI anymore. This stuff has sort of been moved back to you all and to the county for regulation. So does that answer your question?
So, Mr. McGuire, let me restate what I think you said, and let me know if it's correct. So the DRI process, or rights that were granted, those were granted from the state, and that program?
No, sir. The DRI process is no longer in place. If we wanted to go amend, we would have to go through a DRI process. In 2011, Chapter 380 removed the DRI process for mining. Mm-hmm. Okay. So now, as I said, they sort of passed that back to the county. Mm-hmm. And Vanette, if you want to deal with that, that was passed or worked on by her firm of Hopkins. So.
Sure.
Thank you. Good morning.
Mr. Commissioner and the commissioners, Vanette Godelia, Hopping Green and Sam's, I have been sworn.
Thank you.
So I think, just to summarize where the DRI comes into play here. Back in 2011, the legislature mandated that for mines, Chapter 380, the statute that controls all of the DRIs, no longer applied to mines. Mines were just different. And that meant that local governments like Manatee County would, instead of sending things through the RPC up to the state review level, would address all changes to mines here. And you already had a fully fleshed out process here. You had an operating permit, master mine plan, your own significant restrictions. So those processes were to apply post-2011. And so that's what we have complied with. What we are doing now under the LDA is basically rescinding is the process that we call it, rescinding the DRI development order. And it's a cleaning up process, if anything else. What it means is staff and the applicant, Mosaic, went through a detailed analysis of every single condition that was in that DRI. And for things that were no longer applicable because they were obsolete by law, or had been completed on the ground because certain areas had been developed, were basically stricken. And everything else that remained applicable, or retained applicability to the project, was moved into the MMP. So what the LDA does is it's like a vehicle, if you will, for that process. And so if you looked at your LDA materials, what you will have seen is a kind of checklist of conditions, and it showed you the things that were removed, deemed obsolete, and everything else was moved into the MMP. So it's just a nice, clean way of the local government and the applicant agreeing. This process, as required by statute, is no longer applicable. We're cleaning up all our documents so we can all be on the same page. Henceforth, the MMP is the one document that will control, instead of kind of going back and forth between this DRI DO, and this MMP. You now really just have one animal that you're looking at.
Thank you. And
Mr. Chair, could I add a couple of remarks to that, if that's all right? If you have a question first.
a question, just for clarification, this essentially eliminates the DRI.
Exactly. But really, you should think of the DRI, as having been It's a process eliminated since 2011.
Right. Okay. And does this LDA grant any additional rights to the mines?
No, as Mr. McGuire referenced, the only other point was the vesting of the existing rights, which again was just a clean way of making sure everyone's on the same page of what rights continue to apply to the project.
Thank you. Mr. Clegg.
And I do agree with that. The reason I asked the applicant to address it, they are quasi-judicial like the other two items, so we need to get that on the record. And I appreciate you all doing that. Thank you. I know you're going to ask me about it anyway, so I might as well just explain it while they're talking about it. The phosphate mining used to be subject to DRI approval, and what you have in the record are two LDAs for mines that have been in place for many, many years that have those DRI approvals because the statute required them to have those. But then the legislature eliminated that requirement. So mines that come forward today, new mines, are not required to be subject to DRI approval. DRI approval gives you certain vested rights, certain protections against changes in codes or requirements in the future once you have it. And like a lot of different developers that have DRI approvals, Mosaic has been reluctant to rescind its DRIs and come out of that process because of the risk of losing those vested rights. This is not an uncommon issue. It's come up around the state in other jurisdictions, not with respect to mining, but with respect to development. And so what many jurisdictions have done is said, all right, you can move your vested rights from a DRI approval to your LDA, to an LDA, because the statutes work similarly. And then we can no longer have to go through all of the maintenance and work of keeping those DRI approvals in place. It's a lot of work for county staff. It's a lot of work every time we visit, whether or not a change can be made to an existing approval. And it doesn't really add anything anymore like it used to because the state has really backed off of it. We don't get the kind of regional review and scrutiny that we used to in DRIs because it's really a process that's been phased out except for very limited circumstances. So that's what they're asking for, and that's what the LDAs do. Now, I can tell you that from both a legal standpoint, and I think staff's prepared to say this as well, from a policy standpoint, we reviewed these pretty carefully to make sure that they don't create new rights. They simply take the rights they already have that are vested to mine those properties. They've been approved for mining for a very long time. You couldn't take that away if you tried as a government under the applicable law, and just move those into an LDA so that we can get out of the burdens of a DRI process that really doesn't have the meaning that it did years ago when that was required. So I hope that helps the Planning Commission to understand, why they're here asking for that.
Right. And Mr. Clegg, you made a statement. I don't recall exactly how you made it, but you indicated that there was a limited review at the state level now. That's referring to the entitlement of the mining operations, not necessarily the permitting where the authorization to grant activity is given. Is that correct?
Well, new mines don't go through DRIs anymore, so they don't go to the regional planning councils because they don't have to be. They're not subject to DRI approval. So right. I'm not aware of any regional review for a new mine. If they were to come forward today and say we have a new area of land, we're going to establish a mine, there'd be zero regional review.
My question is specific, just to make it clear in my mind. You're saying regional review. That's referring to the entitlement. It still has to go through the Corps of Engineers for permitting.
Oh, absolutely.
So
absolutely.
The county's not taking those rights?
No, sir. We couldn't if we tried. That's Federal Clean Water Act and state law. No, absolutely not.
Okay, all right, understood. Okay, very good. Mr. Brown, did you have something to add?
Yeah, just for policy and the way that these used to run years ago when we had the public hearings with the DRI in place and the master mine plan, they were running simultaneously down the same track together. A lot of what your regional components, such as the transportation issues that were reviewed through the Regional Planning Council, were predominantly in the development order, and we just kind of referred to the development order in the master mining plan. So let's say they were running along the same track. Now, after 2011, this development order basically stopped, and we're moving forward with this master mine plan and changes. And if they wanted any changes, we couldn't make the changes in the development order. And what staff was seeing was quote, inconsistencies. We would make changes in the master mind plan, and then we were asked to look at, and annually they were still doing the annual development order reports. We would look at them and we're saying, no, this is not right anymore because we made these changes in the master mind plan. So this was moving forward. This other one, the DO was a standstill. So it made, you know, a complex issue for the staff to say, you know, the DO was still consistent with the master mind plan. So what, again, it was a very, you know, staff did a great job on both for the applicant and our staff, going through these meticulously, looking at what conditions have already been met, what conditions would need to continue, and basically carving out those conditions out of the development order and putting them in the master mind plan. So there are really no changes per se, no new vesting, no anything other than now we have one document to look at that's going to continue moving along as changes are made, and we don't have to go back and look at that development order and say every year this is inconsistent with what's been approved in the master mind plan.
Thank you. Mr. Rhodes, you had a question?
Just a question. I'm not sure if this might be for Mr. McGuire or Mr. Clegg. So in my mind, then, what's before us, if it could be simplified, is sort of a house cleaning measure that you had all the DRIs that were out there, whether they were still pertinent or they had already been completed. Then at the end of 16, beginning of 17, you had come before us with a lot of different changes, and it was a lengthy meeting, and eventually that was approved early of 17 by the BOCC. So now you're coming to us and saying we're going to take all of these that are still relevant, including what was approved in February of 17, and we're now going to move them into what we're calling the MMP, because I think you stated, Mr. McGuire, that of all the things that coming before us, there was no changes here, et cetera. Is that sort of clear in my mind?
I couldn't have stated it better.
Okay.
You're right on. We didn't want to characterize it as just house cleaning or housekeeping, but, you know, as I said in the beginning, in 2017, February, the board considered a multitude of issues, you know, and we went through so many things, as you said, lengthy hearings here and, you know, remember several days on the other before the BOCC. We all remember that. But what we're doing is exactly what you said, so I won't go back through it. But it was envisioned. What we're doing today was envisioned at that time in that meeting with that language that I quoted to you. So we're back here to go ahead and prepare those others. Remember the first slide. We have to amend those others to be able to operate the Wingate East, because it's going to handle the product, the beneficiation, then it's going to handle the clays. So that's why we're here.
Okay, I didn't mean to downplay the importance of the meeting by using the term
I didn't.
Housekeeping, but to me, I'm trying to see what's happening to the funnel here.
I didn't want to come in here and just say, hey, this isn't important, you know, it's already been approved, because it's not. This is a very important part of the process, but it was envisioned back then, okay? And it is just to make everything in compliance so that we can do what we're asking to, with the caveats that there's no additional, all those things that we went through.
Thank you.
And you wanted some numbers, Mr. Roth. I think you wanted some numbers. Michelle, do you want to respond to that?
Yes, sir. So these numbers are based on the end of year of last year. So obviously they'll be updated in this annual report cycle that started March 31st. It's in progress now. So for the Southeast Track, the general surety bond, it's basically $10,000. That is the bond, and that is for the fact that we do not anticipate any disturbance or mining to occur in the Southeast Tract in the next 5 years. So we just keep it at a minimum of $10,000 in the event that a pipeline area needed to be repaired, replaced, or reclaimed early. And then the reclamation bond, which is based on those remaining areas to be reclaimed, the clay settling area footprint, and the pipeline corridor that has been disturbed and is in current operation, is set currently at $4,151,854. And that bond is based on today's construction standards cost, the cost index, and what it would cost for a third party to go in and fully reclaim those areas. For the Wingate Creek tract, the general surety bond is currently $33,500, and that was based off of the previous year's estimate of areas that we would be disturbing in Wingate Creek. The reclamation bond for the remaining areas, which includes reclaiming the plant site, reclaiming the initial settling area, and reclaiming active mining areas, is currently set at $7,637,930. And since we do not anticipate any disturbance or mining to occur in Wingate Creek, because it'll all be occurring in Wingate East over the next 5 years, I expect that number to be annually reduced with our reclamation accomplishments as we continue to reduce the footprint of the impacted areas. So,
Thank you.
yeah.
Thank you.
Are there any additional questions for the applicant? Thank you.
Thank you.
All right, we're going to move on to the staff presentation.
Alyssa Powers is here for staff. We're kind of short-staffed here, but the applicant's presentation really covered everything, and we support what they had said. We have a presentation if you like to see that, and if we do, I'll ask Alyssa just to kind of skip through some of those areas that we've already covered.
Board's good? Okay, we're good. Thank you.
Thank you.
All right, we're going to move on to the next part of the presentation, or the application hearing. That's going to be public comment portion of the hearing. I've got 2 speaker cards here. Again, there are 4 applications being heard, so you'll have an extended period of time for comment. If you would, just please stay on topic. There's not a reason for filibustering. We'll give you 12 minutes to speak on all 4 applications being heard today. The first speaker card I have today is Mr. David Woodhouse. If you would, come forward, state your name, and that you have been sworn.
My name is David Woodhouse. I have been sworn.
Thank you, sir.
If I may, Mr. Chairman, my comments today, I'm not sure if they're germane to the issue at hand, but I would like to address the effects of the proposed expansion of the mine. Is that in order or not?
It's not being expanded, but...
Well, let me ask you. There will be mining continuing,
yes,
am I
sir.
correct?
Yes, sir.
All right, then you may stop me if
No,
I'm not
please
if I'm not on the right track here.
Mr. Chair,
Anyway.
not to interrupt the gentleman, but we tend to let people talk, and then we do some filtering up here as to what's relevant. So I think he should be given the time that he's
Yes, sir.
allowed to.
If I recall from the last meeting, you've got quite the resume.
I've cut it down to 30 pages.
Okay, very good.
The older you get, the longer it gets. Well, as the gentleman said, I am a professional and registered Florida geologist, and specifically a hydrogeologist. I have visited the Duet mine and am currently engaged in, well, I'll have to use the word, a class action lawsuit in Polk County, which is where that Mosaic release occurred. And I'm asking Mosaic to be good stewards of the land. I understand there's a need for fertilizer, but there should be a compromise here. It is my opinion that any release from the Mosaic plant expansion can and will potentially harm both the environment and the residents. All water and any contaminants will migrate to an environmental sink, which locally can be a river, stream, lake, or ultimately the ocean. In this case, the mine is and will be expanded into a network of the watersheds of the Manatee, Little Manatee, Peace, and Myakka rivers that include the Lake Manatee Reservoir. That's a drinking water reservoir. Domestic wells in the area can create a cone of depression that can induce fluids such as could be released by Mosaic to flow to them. If I may be a little didactic here, Florida is underlain by fractured carbonate rock, which we know as limestone. Any fluid travels downward by gravity through the bedrock and can migrate through a myriad of fractures, potentially in any direction depending on the orientation. A sinkhole can form in the fractures, and in the case of Mosaic, and I'm citing, for example, the Polk County event, the use of sulfuric acid and the subsequent formation of phosphoric acid can actually dissolve the limestone and cause sinkholes. Any migration through the fractured rock of radiation, solvents, and heavy carcinogenic metals resulting from the mining process is critical to the health of the citizens. Now, let me clarify that. There is natural radiation in the phosphate when it's being mined. Solvents, to my understanding, are used during the process. And there are also heavy metals that are indigenous to the rock that's being taken out, and some of those actually are carcinogenic. If I may, I like to use Polk County as an example, and I'm not insinuating what you do here is going to be another Polk County, but I've driven through there, and it's like a moonscape, where you have areas of where they had clay spoils, nothing grows. There's gyp stacks up to 500 feet high, and they do contain these heavy metals and actually radiation. I have a client right now who is downgradient or downhill of the New Wales mine. I have sampled her water. If you smelled it, you might pass out. When she turns on her faucet, black and brown water come out. It's contaminated. There's radiation in it. There's many, many people in Polk County who have cancer, and I call these environmental cancers. Now, I'm not insinuating that this is going to happen. I just want you to be aware of what potentially could be happening. And again, be good stewards of the land. Thank you very much.
Thank you. Okay, the next speaker card I have is Garrett Ramey. If you could come forward, state your name, and that you have been sworn.
Hi, good morning.
Good morning.
My name is Garrett Ramey. I have been sworn. Okay, so I came here today with opposition to this. I've been at the previous planning commission and county commissioners regarding to Wingate East. I'd just like to let you know I hate public speaking. I hate having to take a day off and come down here and do it, but the county has created me, okay? The county has created a citizen that has been trampled upon, and he's here to voice his opinion. I need to know which one of you or all of you who is representing the citizens here. I just need to know who is representing the citizens here today.
All of us.
Thank you, thank you. You did speak up on several matters, and I thank you for that. Okay, so I'm Garrett Ramey, a concerned citizen and bordering resident. I'm here today as a citizen and the bordering resident, and I'm speaking on behalf of several other neighbors. I want to know who is going to represent us. We've gone through so many issues out here in the county regarding mining, and we have not had representation yet. We have not had representation from Florida DEP, from the Army Corps of Engineers, or our good Stuart neighbors as Mosaic to come into an area of compromise. I haven't seen any efficiency within the planning department here also. I requested several documents on Monday the 16th, and does anybody want to guess what time they were available for me to pick up? Today. They're available for me today. With that being said, this hearing, I feel, is maliciously being attempted to be held under the radar. There was not enough time for public notification of these modifications. This hearing was just publicly posted on April 12th, giving only 6 business days of notice and a minimal amount of time for citizens to obtain, decipher, and analyze a rebuttal. We have a lot of experts here. We have a lot of experts here. This is what they do. They've been doing it for years. Some of them should be retired, but they're here because they do a good job at what they do. They're great at master manipulation. This is not master mining. This is master manipulation. If you look at this, this isn't on a if you look at this outside of a per project, look at it at a whole spectrum. Look at phosphate mining throughout the whole state of Florida. We're going to be paying for these sins of our fathers past for years to come. We cannot continue to do this without having somebody oversee this. Mosaic, the applicant, oversees their own operations. We don't even have a third party in there. We have no warning for the citizens at all. We have no air horns for any kind of hazardous incident that can occur. Just on a single basis regarding the public notification time frame, this hearing should be rescheduled and the public should be notified properly. Respectfully, we have another issue as citizens also. I don't want anybody to take this personally, but Attorney Clegg, being present in this hearing, we have an issue with this. After the last hearing regarding Wingate East, Clegg showed his biased representation and favoritism for the applicant. The citizens in opposition were disregarded. Clegg instructed the commissioners how to vote by threat of lawsuits from the applicant. I'm requesting his dismissal from these proceedings and a replacement willing to represent the county and citizens. If the applicant is willing to sue the county for any opposition in order to get their way, is this a friend of Manatee County? What are we doing here? Are we going to allow the applicant to walk all over us and rewrite their own agreements? Are we willing to compromise our mining ordinance at the citizens' expense? Phosphate mining has no benefit to our county. It is a health and environmental disaster, and it does wonders for our property values. And I say that sarcastically because I am impacted by this. We were also labeled as irrelevant by the applicant during the Wingate East Circus that took place last year. During that hearing, Betsy Bennick, as chairwoman, stated, "I don't like phosphate mining. However, the applicant will follow our mining ordinances. There will be no special provisions." And I think we need to maintain that. We must maintain the schedule, especially regarding to reclamation. I want them to do what they do and get the heck out of here. Just do what you do and go so that we can go on with our lives. The balance of reclamation versus mining, not only for this site, but throughout the entire state, is of epic failure. There's no proof that life can be sustained on reclamation, on reclaimed land. In fact, there is a huge lawsuit currently pending in Polk County regarding reclamation. The complainant states in this class action lawsuit, the area to be known as the Poseyden Mine was purchased by the Drummond Company in 1978. In 1982, Drummond ceased mining operations and began to reclaim the, I just lost my place. I told you I wasn't a public speaker. I'm sorry. The Drummond ceased the mining operations and began to reclaim the area and develop 1,400 acres. The document filed in Tampa states more than 40,000 homes sit on reclaimed phosphate mining land in Polk County. Exposure to radiation levels are similar to those identified at the Oak Bridge development, translate to a resident receiving over 1 chest X-ray per week. The lawsuit seeks compensation for loss of property value, for cleanup, to initiate medical monitoring for residents. This is the type of representation that I'm seeking here today, because reclamation is junk, period. I am recommending a denial of modifications and enforcement with penalties regarding reclamation. The only promise we have from the applicant is that they're going to leave the land better than it was before they raped it. They create streams that haven't existed in centuries. They populate the earth with gopher tortoises magically. At Mosaic, and this is their public statement, at Mosaic, we believe lasting success comes from making smart choices. smart choices about how we manage resources. We are committed to significant resources to advancing our efforts in water conservation and land reclamation, waste reduction, and producing clean energy through cogeneration in our phosphate operations. We are also committed to the responsibility and sustainable use of our products by promoting and advancing 4R nutrient stewardship, which we are working to mitigate potentially negative environmental impacts stemming from our product. Improper use of fertilizer. I added our product. We need representation. We, the people, need representation. I pay a buttload in taxes, and I need some representation. We need to decide what we're going to do here. This Wingate East mine, I mean, I don't come here without solutions, okay? I'm not here just to complain. If we want to go ahead and do this land use change or this mining modification, let's go ahead and do that. But let's go ahead and change the status back to the Wingate East. Let's change that status back to agriculture until they're prepared and ready to do this. If they want to extend this another 14 years on this side, then let's just wait. Let's wait to allocate that land for that usage. We're getting way up over our heads. We're putting the cart before the horse. We can't continue to do this. This is going to come home to roost with us one day. It's not a matter of when, because it's going to happen. One major hurricane and we're done. We were lucky during Irma. They only had 2 breaches, or I believe 1 breach. Is that correct? I think I've said what I needed to say today. I'm sorry I'm not very charismatic, but this is the truth, and this is where we stand as citizens, and we need help. I'm asking for help. Thank you.
Thank you. Those were the speaker cards I had. Is there anybody else in the audience who wishes to come forward and speak? If you would come forward. Have you been sworn? No. Okay. Is there anybody else in the audience who wishes to make a statement? If you would, please rise to be sworn. Okay. All right.
Do you swear or affirm that the factual statements and factual representations which you're about to present to the Planning Commission will be truthful and accurate? Thank you.
I just have a few questions.
If you could, please state your name. And
Oh, I'm sorry. My name is Marcia Cox.
we all saw you were sworn. So.
I have a few questions from David Woodhouse's comments that he made. I know you bought some property.
Sorry, Mr. Chair.
Yes, ma'am.
She does have the right to ask questions of the applicant, but those need to be presented to the chair, and then the chair will ask them of the applicant.
Oh, I'm sorry. I was just making reference.
I understand. That's fine.
To
Please address it to the chair.
Okay. Well, the mine bought some property that they are using for a preserve next to what you're going to be mining in the future. That is the Myakka River head at Duet. And you talked about the bonds and how much money in case of breach that starts the tributaries of the Myakka River and goes all the way down and goes out to the Gulf. I'm just wondering how close you're actually going to be getting to that particular preserve.
If you would just ask the question, and in their rebuttal, they can address those comments. So they're not gonna respond to you now. It'll be during the rebuttal. So.
Correct.
So just ask your questions or make your statements.
Right, and also, that's Duet Headwaters, where they're really close to mining. That's a lot of wells. That's our drinking water. I'm just a little concerned about how close they're actually getting to everything and what kind of, that's your drinking water. Everybody's drinking water. It goes to the reservoir. Just making that statement. Thank you.
Thank you. Okay, is there anybody else who wishes to come forward? If you would, please come forward, state your name and that you have been sworn, please.
My name is Nathan Elliott. I have been sworn.
Thank you.
I'm a property owner at 409 11th Avenue. The back of my property is connected to Mosaic. I got my letter last night telling me about this meeting. I didn't have a chance to look at anything. I went to work at 10 o'clock at night. I got off work at 7:30 this morning. I work for the post office. That job there is going to be helping build my house on land adjacent to their facilities at Wingate. One of the things Ms. Tickles said was that the bonds would go up and down. The general surety bond would go up at the Wingate facility in her first portion of her statement. When given an opportunity to clarify how much the Wingate bond was, she said that she foresaw that it would be reduced yearly. If the activity is going to be getting busier, why would it go down? And if I'm correct, the Wingate facility is the one that was highlighted in blue? Is that correct?
Again, just make your statements and it'll
I'm
be
concerned about the increased activity in one statement, and then the next statement, when she's given an opportunity to speak again, it's supposed to go down. I wasn't given an opportunity to get a copy of their proposal. I didn't get a copy of what the staff has for their presentation. Managed to get here on time and get sworn in. And I've listened, and I'm just trying to learn.
Yes, sir. If you would, after the hearing, maybe get with staff, they can direct you to how you collect the information with regard to the hearings. It comes out a couple days in advance. I know we get notice and it's available online, but sometimes it's a little bit difficult to find. But staff can direct you to that.
Okay.
Thank you. Okay. Is there anybody else in the audience who wishes to come forward and make a statement? Anyone at all? Okay, seeing no one else come forward, we're going to close the public comment portion of the hearing, and we're going to move on to discussion, or actually
Staff rebuttal.
staff.
We need to do staff or applicant rebuttal, Mr. Chair, and I do want to make sure that the two questions that were posed do get addressed. I think staff is prepared to address the second one about how the bonds are adjusted. I think that'd probably be better for staff to address that.
Right, I've
I
made
do
note.
think before that, I think that the applicant should address the first question that the woman came down and posed to the Planning Commission.
Right.
We have to do this as a matter of procedural due process. They ask for a question to be answered through the chair. We need to make sure that happens. So I would ask that we take care of those.
Yes, sir. Okay, so the first is the staff closing comments, and this would be the opportunity to provide clarification regarding the bonds. So
I'll defer to Alyssa.
okay.
Okay, so hi, my name is Alyssa Powers, and I have been sworn.
Thank you.
Sorry, I'm the mining section manager for Parks and Natural Resources, and I'm one of the staff members that go out monthly to inspect the sites, review the progress of reclamation, progress of mining, active mining, and just what is going on the ground. So with the reclamation bonds, which are reviewed and updated annually, I would like to just first state that the general surety bonds that we talked about, those are only every 5 years. So as part of the operating permit, they put into place a general surety bond, and that looks at a 5-year picture because that's the length of our operating permits. They have to come in every 5 years under a master mining plan and get an operating permit. So those are reviewed every 5 years. For the reclamation bonds, those are reviewed annually with the annual reports. And so the areas that are in, it's kind of a little confusing, in the upcoming year that are to be disturbed or mined, those then start into a table of reclamation dollar amounts. And those are the higher cost amounts because nothing has been reclaimed, right? These are the ones that are disturbed. And then as they go through a reclamation process with backfilling with sand tailings, and then they'll vegetate, they may muck for wetlands, and then it has to grow and develop. Those are different stages, and there are different dollar amounts that are reviewed as part of that. So that's where that first piece then will get reduced as the years go by from when it was first disturbed, and that would be the highest dollar amount down to the lowest dollar amount when it is reclaimed and released and may just be under maintenance. So that's how the process works, and there was maybe a little confusion in that with Wingate Creek Mine, that because of Wingate East, they're going to be mining Wingate East first, and they're going to be coming in with a reclamation bond for Wingate East. And that will be, for the 5 years, what they're going to mine and disturb will be bonded under Wingate East. Wingate Mine, which is already disturbed, there are areas that were approved for mining that are going to be deferred until Wingate East Mine is done, because the dredge will move from one back into the other. So those will be maintained as disturbed right now until they go to mine it. So that's where the dollar amounts will change up and down depending on whether it's just disturbed to whether it goes to mined to whether it goes to reclaimed. So, up or down, 100,000, 500,000. It moves depending on what it is. But what I believe Mosaic was trying to say was that the Wingate East will be coming first with the mining, and so that reclamation dollar amount will be added on. That hasn't been assessed yet, and then the Wingate Creek mine that Michelle had read into. For the $7 million odd there, that will be adjusted accordingly as they are holding their disturbed areas to be mined in the future.
For clarification, when is the reclamation bond required? Is it prior to turning any dirt?
Yes, absolutely. The reclamation bond is required at the start of the operating permit. So when they go to the board, the operating permits go to the board, the reclamation bonds, the initial reclamation bond goes then to the board. And then it's annually with every annual report. They get updated and they're on the consent agenda every year.
And then the bonds are released when the county accepts the reclamation?
So the whole entire bond will eventually be released, but that's where the dollar amount just goes up and down depending on the amount of reclamation that has been done or the amount of disturbance that has been done.
So when you say it goes up and down, it will go up if area is added to the disturbance. It'll go down if areas have been reclaimed and are accepted by, again, what agency accepts
the county, and that's correct.
So, okay. All right. Additional questions for staff? Okay. With regard, one of the other things that was brought up was noticing. I think there were several neighbors who mentioned noticing. Could you explain the noticing policy and again, was it properly noticed?
So the noticing policy is 10 days for public notice in the newspapers, and we further follow the mailings as well and the signage in front of the site. So all three of those were done at a minimum of 10 days. I believe it was actually 11 days.
And Mr. Chair, the affidavits are always put in the record when we have these hearings, and they are in this case as well.
Right. I know, I saw them.
All right. Thank you.
So, yeah, so there were newspaper affidavits, there were signs posted in front of the sites, and then the mailings to the residents within 500 feet. We do all three of them.
Thank you. Thank you. Any additional questions for staff? All right, if there aren't, then we're going to go to the applicant closing comments. So, all right.
Can I ask one question?
Of staff or the applicant? Allow them to make their rebuttal, and then.
Okay, you got it.
Mr. McGuire or Ms. Tickle?
Again, Michelle Tickles with Mosaic, and I've been sworn. Just to go back to the question about the preservation area, I believe the areas in reference are the preservation areas associated with the Wingate East Mastermind Plan approval. There's several unrelated setbacks in the Wingate East area that aren't in Wingate Creek or the Southeast Tract. So depending on the specific area they're talking about, changed the setback. So without knowing the specific area, I know there are setbacks related to some of the preservation or watershed boundaries in Wingate East, but again, there aren't preservation areas of note that have any active mining operations discussed for Wingate Creek or Southeast Track today.
Okay. And when you say setbacks, you're referring to a dimensional
Either
measurement, not an operational element that has faulted?
related to Wingate East, it could either be something required by the code itself or something associated with the distance between the preservation area and our best management practices before the mine cut face. So it could be either of those distances, but generically we'll call them setbacks.
They're distances, not operational failures.
Yes, Commissioner. Thank you.
Thank you. All right. Again, Mr. McGuire, applicant rebuttal.
Commissioners, Hugh McGuire, I would just reiterate briefly that I hope we've answered your questions. If you have any additional questions, we would be more than happy to answer them. But I think that some of the items that we've heard discussed are items that were considered in very lengthy hearings in February. As a result, if you don't have any further questions, we have no further testimony or any further comments, and we would respectfully ask for your approval of the 2 master mining plans and the 2 local development agreements.
Mr. Rhodes.
Mr. McGuire, just for the record, so to speak, and for from Mr. Wodehouse who spoke and Mr. Ramey that spoke, both of them, they were talking, brought up some concerns that were related to special provisions, extensions, and modifications, okay? Of which none of those issues are before us today with what you're presenting. And I just want you to state that is correct so they know their concerns are not before this commission for discussion and eventual approval today.
Mr. Rhodes, that's what I was trying, maybe I'm not articulating. What I'm trying to say is so much of this has been covered. As you know, this is not a debate on whether or not we have the right to mine phosphate. It's not an issue of rezoning land. It's not an issue of withdrawing more water. It's not an issue of establishing new clay settling areas. It's not an additional trucking issue. It is approval of these, and I think that that was articulated by Vanette very clearly, that it's a cleanup, so to speak, on the MMPs, the master mine plans, and then we're moving the vested rights into the LDAs. So these issues, and I understand their concerns, and we've heard these concerns, and we've tried our best to answer these concerns, and that's where we are. So does that answer your question?
Yes, it really wasn't mine. I just wanted to make sure that the 2 speakers who had concerns understood what was before us for a vote today.
Yes.
Mr. Chair, could we I think Rob and I both need to make a couple of clarifying remarks on that as well, because what you have in front of you today, I do think it's a fair characterization as housekeeping changes and modifications to existing approvals. And as you all know, the Planning Commission's role is to look at those and determine whether or not they're consistent with our code and our comprehensive plan. That's the decision you're being asked to make today. So I don't disagree with Mr. McGuire, but I do think it is important to understand that there is embedded within there some time extensions. There are time extensions. They are not decisions on whether or not you're going to allow mining to take place on these properties, because that has been decided, as Hugh pointed out, I think quite correctly. But I think, Rob, you could just briefly explain.
Yes.
I don't want any inference that we haven't explained that to the Planning Commission and have somebody later say, we didn't tell you that, because it is part of the decision.
Again, it is a time extension for these existing mines. It's an extension for Southeast to use the clay settling areas. It's an extension for Wingate Creek Mine to use the trucking and the beneficiation plant. So,
Those are for the Wingate
right.
East. I mean, you explain that.
Correct. I mean, for them to process Wingate East, which has been approved, they're going to have to utilize the infrastructure in those 2 facilities. So what that does is extends, and in the advertisement, we're saying for Wingate Creek Mine, we're extending the build-out date and mining until July 31st, 2037, trucking till July 31st, 2037, and reclamation until December 31st, 2042. And for Southeast Tract, that goes to build out of mining until September 30th, 2037, and reclamation until 2030th, 2042. So we are extending the life of those two existing mines by utilizing that infrastructure.
The life, but not the footprint.
Correct. Just the life of the mine.
Yes.
It'll be extended to be able to utilize. And again, the positive aspect of that is they're not going to build a new plant. They're using the plant that's already, beneficiary plant that's already in existence, and they're not going to build any new clay settling areas. They're going to utilize the ones that are already there.
And I appreciate that comment. That was what I was going to say, because I think that's the very important takeaway from this. We're not establishing a different plant site. We're not building new clay settling areas. We're utilizing what we have.
What was the origin of the original time frame? So that was the DRI?
No, we have one in the what's the existing mastermind plan build-outs? I knew Alyssa's got this.
Okay, so the build-out date for Wingate Creek Mine currently is July 31st, 2023. And the build-out date for Southeast Track currently is September 30th, 2023, with reclamation completing September 30th, 2027 for Southeast Track and December 31st, 2027 for Wingate Creek.
Thank you. Any additional questions for staff? Mr. McGuire, is that your?
Yes, sir, that concludes our presentation.
I have one question for you. What is the typical communication or notification with neighbors? Does Mosaic have a specific process that they follow with regard to communicating?
They do have meetings. Jackie, you want to come speak to the public notification, public participation? Jackie Barron, I'd like for her to speak. You've been sworn?
I have not, so I would have to. The one time I don't swear in, I should.
Do you swear or affirm that the factual statements and factual representations which you're about to present to the Planning Commission will be truthful and accurate?
I do. Commissioners, my name is Jackie Barron, and I handle community relations in Manatee County for Mosaic, and we have community meetings. We are due to have one for the Winding Creek community, our closest neighbors. We also have a community advisory panel in the county, which is a group of folks that come from various walks of life and meet once a month, and that group, as a group, has held what we call Good Neighbor Nights. We've had a couple of those in Mayaca City where we invite folks from across the area to come and ask us any kind of questions from reclamation to job opportunities. So we do quite a bit of outreach out there. And we have made sure that especially our closest neighbors in Winding Creek, they have our phone numbers, they have my cell number, they have the mine manager, David Kennedy's cell number, and it is not uncommon for us to get calls, and we appreciate those and welcome those. Anytime they have a question, there's no question too small.
Thank you.
You're welcome.
Thank you. Mr. Roth?
Yeah, what were the dates for the abutters being notified? A week, 2 weeks before, or what?
Is this in reference to this application, or?
This application.
I think Mr. Brown might have answered that. They said 11 days prior. I'm sorry.
That was us. How about for the abutters?
No, I think that's the same thing. I think you're asking the same thing.
Yeah, that would be the applicant that does the mailing, isn't that right?
Yes, sir.
Yeah, would you explain the mailed
They
notice?
were
I think
mailed.
he's asking about mailed notice,
I did
not
them
published
myself,
notice.
okay?
Okay.
They were mailed, okay? And I have been sworn, okay?
He's asking, though, how far in advance were they mailed?
11 days. And if I'm not mistaken, the sign was posted 11 days.
Mr. Chair.
And we have pictures of that, if you would like to see.
Yes, ma'am.
I'm Tana Acevedo with the clerk's office. The affidavit of of posting, of publishing, states April 12th, 2018.
Thank you.
And that's with the agenda materials that were posted online with e-agenda.
Mm-hmm. So for clarification, Mr. McGuire, the burden falls on the applicant to post the signs, to post the affidavit, and to do the mailings.
Yes, sir.
So
we do. We are furnished a list. We send the description of the property and the packet comes from the county. We send it to the property appraiser. They send us back labels. We prepare the mailing. We mail it. We sign the affidavit of mailing, and I put them in the little envelopes. My wife and I.
Yeah, thank you.
My partner.
All right.
So I know they went. I like to do that, okay? I'm glad you asked that question. I've been waiting years for somebody to ask me that question, okay?
All right. Thank you, Mr. McGuire. Okay, we're gonna close the testimony portion of the hearing and open it up for discussion or deliberation. And again, when considering motions, just remember we have 4 motions. Probably the most appropriate thing would be to take any motion in order as they're represented in the agenda.
Mr. Chair,
Mr. DeLesline.
I move to recommend adoption of LDA number LDA 1704, local development for the Wingate Creek Mine and rescission of DO ordinance 0820 as recommended by staff.
We have a motion. Is there a second?
I'll second.
Mr. Ron, second. Is there any discussion or deliberation on this matter? Okay, the chair will call the matter to the vote. All those in favor say aye.
Aye.
Opposed, like sign. Chair votes aye. Motion passes 5-0. Chair will consider a motion on, or will call for a motion on item number 2.
Mr. Chairman,
Mr. Rhodes.
on item number 2, I move to recommend adoption of LDA 17-03, local development for the Southeast Track Mine and rescission of DRI-DO ordinance 08-20 as recommended by staff.
I have a motion. Is there a second? Second. Mr. Roth, second. Any discussion or deliberation? Chair will call the matter to vote. All those in favor say aye.
Aye.
Opposed, like sign. Chair votes aye. Motion passes 5-0. Chair will hear a motion on item number 3. One is
Mr. Chair, I'll make the motion.
Mr. Ron.
I move to recommend adoption of resolution number R18012, master mining for the Wingate Creek Mine as recommended by staff.
Mr. Chair, I'm sorry, could we have clarification that you're making the recommended motion in the staff report because it has the reference to consistency with the comp plan? You don't have to read the whole thing. You can just say,
Yes.
I'm making the recommended motion
Yes.
as set forth in.
As set forth by the staff report.
Thank you.
Thank you. We have a motion. Is there a second?
Second.
Mr. DeLesline, second. Any discussion? Chair will call the matter to vote. All those in favor say aye.
Aye.
Opposed, like sign. Chair votes aye. Motion passes 5-0. Item number 4, Chair will, yes, Mr.
Mr.
DeLesline.
Chair, I move to recommend adoption of resolution number R18013, master mining for Southeast Tract Mine as recommended by staff.
Have a
Second.
Further staff report.
Again, we'll just clarify you're making the recommended motion that's set forth in the staff report?
Yes, sir.
Thank you.
In the staff report.
The staff report.
Have a motion. Is there a second?
Second.
Mr. Ross, second. Any discussion? Chair will call the matter to vote. All those in favor say aye.
Aye.
Opposed, like sign. Chair votes aye. Motion passes 5-0. So that concludes our scheduled agenda today. Is there anything else before we close the meeting? All right, we're going to go ahead and close the public hearing. Thank you.
Thank you.